over the house.
What are you mentioning, sir? Where is the memo?
Old matter, item number 1.
None appeals to the petitioner. This person not present.
Special weekly daily list, item number 2.
I let no instruction.
No instructions. Dismissed this.
Item number 3.
None appeals. Oh,
Stay.
Here it's a delay of 5 years. State
5
years. About.
years. Okay. Delay of 5 years, not properly explained. Dismissed.
Special weekly, item number 4.
Alert, this is infructuous. I'm on the VC matter.
All right. The petitioner states the petition is rendered infructuous. Dismissed as such. All right.
Special weekly, item number 5.
Item number 5, Milords. It'll take some time to reconstruct the file. Just 2 days time. Let it be on the board.
What is the matter about, sir? Why is this thing?
Milords, here we are challenging the order of the appellate forum. Milords, the issue is whether the labor percentage that has been
What is the tax effect? What is the tax effect?
Tax effect is 6 lakhs or more, Milords.
All right. At the request of counsel to the petitioner who needs time to reconstruct his file. Let's next Monday.
Milords, next Monday, Milords.
Special weekly, item number 6.
Item number 5 may only pray that for the department, one of my colleagues' name may be reflected. He was
All right.
But I have some. I was
Write it down, sir. Write it down and give it.
Special weekly list, item number 6.
So item number 6, Milords. Only one question is involved in this case at page 9, Milords.
Court fee not paid, 29 rupees, court fee not paid, it says.
Milords, amount in dispute is what?
And delay, what's the delay? Delay is also there, sir.
It is not paid.
31 days. All right. Delay of 31 days is condoned. And then no question has not yet been framed.
Question, Milords, no. Only one question is involved, Milords. Page 9. Whether in the facts and circumstances of the case, sale of groundnut seeds by the petitioner to Orissa State Seeds Corporation is exempted under entry 35F/35FF of the tax pay schedule or is taxable at the rate of 4%. Yes, there is no denying the fact that what is sold by this petitioner to Orissa Seeds Corporation each mirrors groundnut seeds. And secondly, it has been channelized to Orissa Seeds Corporation. Whereas the entry 35FF mirrors was there till 36/2000. Your lordship is concerned in this case for the year 2000-2001. From 1/7/2000, that entry was omitted.
Right.
Substituted by another entry. So what I will take your lordship's attention. The Joint Tribunal also mentions page 17. My lordship kindly see. I am also giving your lordship the relevant entry.
So only for 3 months.
Only 3 months. To my opinion, I will be entitled to benefit of the Joint Tribunal.
Tax effect must be very low, sir.
What will
be the tax effect?
Unlike 44,454, I will be at least get the benefit for 3 months. All other periods, I am not pressing. I will not press for the rest of the periods.
All right. So 35FF was omitted
omitted with
From-
effect
with
from
effect from
1/7/2000.
Correct. Truthfully labeled seeds of
Yes.
groundnut.
Yes.
Ah.
The last entry I am covering,
Right.
because I will cover, and from 1/7 this is not there. Then
Right.
certification process started, which I have not given. That is the allegation.
No, why did the tribunal dismiss it?
Lord Tribunal says that you have not given any certificate which is required to be furnished, my lords.
Ah,
So that is how, and for the entire period, Lord Tribunal findings, my lords, be kindly. So that is at page 17.
right.
We have heard Mr. S.K. Mahathir, Lord Counsel for the Appellant, Mr. B. Ekar, Lord Assistant Headquarter for the Respondent.
So that certification agency certificate is not there.
Not there, no.
Then
Then that for the 1/7/2000, I will not be entitled.
no, but even earlier than that, you still need a certificate, sir.
Earlier, minutes, only
It's not automatic. It has to be certified.
Sir, that's the government of Odisha
No.
Corporation. As you not see, Milord.
You say the short question that arises for consideration is whether the petitioner was entitled for exemption up to the period of 30 June 2000 from payment of sales tax on seeds sold by the petitioner to the Orissa Seeds Corporation.
Groundnut seed, by the way.
Seeds of groundnut to the
Groundnut
Orissa,
seed.
groundnut seeds to the Orissa Seeds Corporation. Question mark. Paragraph. Apparently, entry 35 FF in list A of the rate chart attached to the Orissa State Tax Act was operative till 1st July 2000. Full stop. However, the conditionality for exemption of sales tax was that the groundnut seeds sold had to be, open quotation, truthfully labeled, unquote. In other words, it had to be properly certified by a certification agency. Admittedly, the petitioner did not have the requisite certificate. And therefore, the tribunal was not inclined to grant the relief. Having heard Mr. Sahul and senior counsel for the petitioner, the court is unable to find any error having been committed with the tribunal. No substantial question of law arises.
Special weekly list item number 7.
Lord, item number 7, there are similar matters in item number 2 and 3 of the weekly list. So let all these be taken up together.
All right.
Of today's weekly list, item 2 and 3,
All right.
similar matters.
All right.
Special weekly list item number 8.
None appears to be.
Special weekly list item number 9.
So item 9 blocks, there are in fact 3 tax revisions. One has come, other 2 has not come before also blocks. So far as this matter is concerned,
Yes.
question is at page 10 blocks. Page 10.
Yes. Whether in the facts and circumstances.
Lawful determine the issue of ownership is concerned for assessment and consequence legal obligation arising out of the provision of section 12(5) of Orissa Sales Tax Act for the disallowance of notified first point goods and levy of tax in view of section 8 of the Act law. That's 2 things I will bring to lordship's notice of precise ground, then I will take it. That this is an unregistered period, initial period during which inspection has taken place, and based on that report, demand is raised. They have determined initial liability, continued with further liability, raising this demand. That's one dispute is the petitioner before lordship. He says that my son is a proprietor. Son says so. Therefore, the ownership that I am not arguing.
Then what is there, sir?
Yes. Secondly, substantially, lords, in this case, goods are procured locally, which are first point tax paid. And dispute some penalties also imposed, and the entire assessment is made based on estimation. So, may I pray, subject to my friends agree. If the entire demand for 3 other 2 periods also there, if it restrict 50% to end.
No, sir.
With
Can't
the end of
simply be like that.
Because this is
not
purely-
local adalat.
This is purely on the estimation only.
No,
Only
this
estimation.
is not local adalat, sir. Please.
As my last speaker, otherwise I
You say
don't have.
having heard learned counsel or learned senior counsel of the petitioner. The court is not persuaded that any error has been committed with the tribunal as regards estimation of the tax payable by the petitioner in the initial period prior to grant of registration. No substantial question of law arises. The petition is dismissed.
Item number 10.
So then. This is one of the matter. question arises for your lordship's consideration is that the purchase of dal, declare this is a small scale industrial unit coming under 80 policy measures. The authorities below, they have disallowed my claim of exemption on purchases, even if a declaration form 1A is furnished, on the ground that you are ineligible to avail the benefit exemption. Two things below what I have purchased. One is below dal, and second is below groundnut I have purchased, and after process of decortication, ground out of what groundnuts are being produced. As my lords knows, for the purpose of availing benefit exemption, that need not strictly manufacture. Processing are also covered, and if there is certification, then. And what I find after examining things, under 80 policy, the ineligibility was not there in the notification. It was there in 86 policy. I am giving to your lordship here. Two things I will bring lordship. One is Apex Court's decision, Honorable Apex Court said, if it is there in the IPR, on the basis of IPR, nobody can claim the exemption unless the exemption flows from the statute. Here, 80 policy I have seen, there is some ineligibility, mention of ineligibility. But in the notification, your lordship will find entry 26A. That is the relevant entry, my lords may kindly see. 26A, purchase and sale of raw material that goes direct composition of finished products, so inside this 80 policy. Then your lords may kindly see the condition. The exemption shall be allowed for a period of 5 years from the date of certification of the unit. This is there. Findings I will take your lordship's attention that eligibility, there is no denying the fact that only thing what the London Tribunal says that because this is ineligible, so therefore you cannot. Now your lordship may kindly see the entry. See appendix 1A, only form 1A. But under 86 policy, under that is 26D. 26D, your lordship may kindly see. There is a list of ineligible units. So therefore, for 80 policy, as per 26A, this ineligibility which the London Tribunal has referred to is not available. I rely upon judgment of that Durga Oil Mills case, which says that if it is there in the IPR, on basis of IPR, you can't disallow. Whether I am entitled or not entitled, that will determine only from statutory entry. And statutory entry doesn't provide an ineligibility. You know, kindly see book, old book. List your lordship may not have. 26A I have given, 26D your lordship kindly see, the next entry.
That you've given a photocopy.
I have given photocopy for 26A under 80
No,
policy.
26D also.
D also. Next.
Second
I think-
page.
No, D is there partly there, but the next page, yes, next page. My lords may continue with 26D. Your lordship will find at the bottom, there is a list of ineligible units. And your two things you will find, pulse mills and decorticating.
Pulse mill is there.
Pulse mill and decorticating. Yeah, because groundnut your lordship decorticating and pulse mills preparing dal. Yes.
Right.
So these two are ineligible on 86 policy, not on 26A, on 26D only. That is my only case, Lords. And London Tribunal disallowed, saying that because you are coming under ineligibility list and it's not valid, so therefore you are not entitled.
No, but you are under the ineligible list as far as 26D is concerned.
So we are not coming on 26D. 26D for 86 policy. I am giving only to let my lords know that whether ineligibility is there for 26A or 26D.
No, which is the period we are concerned with?
Your lordship is not concerned 26D. Your lordship is concerned 26A only, my lords.
No, which period are we?
This is for the period, my lords. 98, 99.
98, 99.
Yes.
No, 88, 89.
88, 89.
88, 89.
So sorry.
So this ineligibility is already attracted then under 26D, which is 88, 89.
No, that is that already admittedly, this is a exemption claimed under 80 policy, 5 years from the date of commencement of commercial production. And admittedly, this period falls under 80 policy because the period is covered by this, my lords. My lords may kindly see the finding. Your lords may kindly see the finding at page 22. Page 22. 6 lines from the bottom, page 22.
Yes.
Now it is to be decided that whether the dealer is eligible to purchase pulses and groundnuts from the unregistered dealers on the strength of declare 1A. As discussed earlier, the dealer is SSI unit duly certified by DIC. But these industries, pulse mills and decorticating of oilseeds are declared ineligible to avail the benefit of exemption. The incentives of legislature in this regard are very clear. Although they are counted as industry, no sales tax incentive provided to them. So we are therefore further, as discussed earlier, processing of dal and pulses, decorticating groundnut to obtain groundnut seeds do not amount to manufacturing of dal and groundnut respectively. Therefore, in opinion, the dealer is not eligible to purchase pulses groundnut on the strength of 1A forms. So, minutes, my humble submission, I am coming under minutes 26A. 26A doesn't provide for it. Subject to my friend may verify whether it is there.
Well, I'll go through this IPR, which my learned senior has furnished today.
All right. If at the request of counsel for the state, who needs time to verify the detail. Next Monday. Next Monday.
Yes.
Item number 11.
These other two connected matters to that 9, item 9. Shall we take it on board and dismiss it because you've dismissed this today?
Other 2 items.
All right. Which are the 2 items? Just give us the numbers.
STRV number I am giving 61 and STRV 64
61
of 2009.
order passed today in 62 2009. These are also. All right.
Special utility list item number 11.
11 millards. Petitioner before RCB Bhubaneswar Development Authority millards.
Right.
Because BTA has supplied some materials to the contractor on cost recovery basis. Question arisen, which has arisen in this case, millards, whether supply of goods by the contractor, namely BDA, to the contractor on cost recovery basis constitutes sale or not.
Oh,
And this is in fact answered by Honorable Apex Court in Hindustan Sales case, saying that whenever goods are supplied on cost recovery basis, this is sale by contractor to the contractor, and when this is executed by the contractor, again by way of transfer of property in goods, second sales takes place from the contractor to the contractor. But one thing, Milord, my humble submission is there cannot be 2 sets of taxes on the same transaction,
I know
both
that
in the
you are-
hand, yes,
yeah,
contractor and also BDA.
correct.
So that part my friend can answer because I don't have anything whether my contractor is assessed to tax or not. I'm sorry
We are
to
only
say
concerned
nothing.
with this limb of the transaction. We don't know what has happened later. See, the short question that arises to consideration is whether the supply by the petitioner of goods to the contractor for execution of the work of construction amount to transfer property in the goods and therefore will amount to state. Question mark.
My lord is disposing of the matter.
Yes, that is, we are not agreeing with
And
because the Supreme Court has answered it.
no, my lord, thereafter many Supreme Court judgments have come after Hindustan Steels. My lord, I have all these judgments where it is said that if transfer on cost recovery basis, that would amount to sale.
That's what he's saying.
That's
He's
the
also
time.
saying that only. He's conceding that
Oh.
the petition has to be dismissed, sir.
Beg pardon.
Except that I want that my friend may verify whether the contractor has already been taxed. If he is taxed, there should not be multiple tax on same time, both on BDA and contractor.
It has been
To that
held by the
extent,
Supreme Court in Hindustan Steel Limited versus yeah, versus State of Orissa, 1970, 25 STC 211. That supply of goods on cost recovery basis would tantamount to sales. That is the matter, no substantial clause.
Special utility list item number 12.
delay.
Government say judicial officer, paying for stepping up pay. Kind of
No, sir. I think you're on a different list.
order dated 4-3.
No, you're in a different list.
Special weekly list old matters.
How many days delay, sir?
I said 26 days.
Ah,
Lord would turn to the question of law.
what's the tax effect? That's the next question.
Tax effect is 7 lakh some odd. But here, my lord, the question that has been raised is regarding enhancement.
Ah.
In fact, your lordship would turn to internal page 7 of the tribunal's order. Internal page 7 of the tribunal's order.
Yes.
The assessing authority has found the actual suppression at 18 lakh some odd, and he has enhanced the turnover to 1 crore 61 lakhs. But thereafter, although the appellate authority has reduced the actual
75
suppression
lakhs.
to 11 lakhs, but he has sustained that enhancement of 1 crore 61. That is why the tribunal has said that when the first appellate authority has reduced the actual suppression, he ought to have reduced the enhancement.
Correct.
So, and tribunal accordingly has reduced the enhancement from 1 crore 61 to 75 lakhs.
So we'll not interfere. You say the short question arises for the determination in the present case, namely whether while examining the plea of the SSC in appeal, the tribunal is justified in reducing the enhancement of the gross turnover from 1.5 crores to 75 lakhs towards suppression of sale for the year 2001-02. Paragraph of perusal of the impugned order, the tribunal reveals that the first appellate authority had already reduced the demand, reduced the amount of suppression, and therefore it was only logical that the enhancement of the GTO also be reduced. No substantial question of law arises.
Special weekly list item number 13.
Item number 13 minutes, question at page 14. Whether in the facts and circumstances case,
The 1,000 rupees you don't seem to have been paid for delay condoning. You had to pay 1,000 rupees. You have not paid that.
who was paid?
Orissa High Court Bar Association Welfare Fund. You have to pay 1,000. That proof of payment is not there, sir.
Proof of payment, I don't have. One second. Receipt recorded. Oh, I'm sorry, difficult to find out.
The amount of rupees 1,000 for continuation of delay, as ordered with sport way back on 21st September 2015, has not yet been paid. That leaves matter the delay in filing the revision petition is not condoned. Consequently, the revision petition is dismissed. Yes.
Special weekly list item number 14.
Question to remain open.
All right. The questions are left open for consideration in some other case. All right.
Item number 14.
None appears dismissed. Not possible. All three. 3 or 4, 5, 6, 7 matters.
Special weekly list item number 15.
Then, my lord, steps for limitation have been not taken, and also the tax effect is 63,000 some odd.
All right. In view of the insubstantial tax effect, and steps also not having been taken for condonation of delay, the petition is dismissed.
Special weekly list item number 16.
Item 16, tax effect is very less, so
Alright.
let the question may be open.
All right. The tax effect being minimal, court is not inclined to interfere. However, the questions of law are left open for decision in some other case.
Special
Both
weekly
the-
list item number 17.
17, my lord. My lord has answered this question in another STREB 541 of 2008, order dated 20th June 2022 against the department. So
All
same question.
All right, in view of the order passed in this court on 20th June 2022 in STRED. (541) of 2008, bracket State of Orissa versus Mrs. Poonam Distilleries Limited. The present revision petition is also.
Special weekly list item number 18.
Might be the Lordship. I pray your Lordship, sir, take up this matter tomorrow, my lord. I am not conversant with this file, my lord.
Sorry,
Maybe taken up tomorrow, my lord.
all right, list tomorrow. At the request of council petition list.
Special weekly list item number 19.
That appears to dismiss on opposite.
Item number 20.
That appears to dismiss on opposite.
Special weekly list item 21.
That appears to dismiss on opposite.
Special weekly list item number 22. Item 22.
That appears to dismiss on opposite.
Special weekly list item number 23.
23 may be permitted to withdraw, my lord.
Council for the petition seeks leave to withdraw the petition. Dismiss is withdrawn. Right. Right.
Special weekly list item number 24.
24, my lord, delay of 40 days and tax effect is 26,000.
Or
So delay may be condemned.
Delay is condemned. You did substantial tax effect. The question of law officer. Petitions.
Special
Same 25 also.
My lord,
20.
43,000 is the tax effect.
Or 25 the same.
Special
25,
weekly item 26.
25, I am appearing, my lord.
Or this note is appeared.
Item number 26.
None appears. This is not possible.
My lord, this is a,
You are in 26.
my lord, this is a matter regarding challenging the punishment pursuant to a departmental proceeding, my lord, disciplinary proceeding. The petitioner, while was a reservation clerk that in railway, he has issued some tickets on basis of privilege past of a class 1 officer, and that was the subject matter of challenge, my lord. My first, my lord, annexure 1, my lord, that is the memorandum charges, page 15, Lordship kindly see, that article 1, they have stated, Sri Behera, this is the petitioner, has issued the PNR ticket in favor of one Sri S. Das, in addition to the other authorized family members of BC Chakravarti. He was privilege past was issued in his name. Sri Das was neither a dependent member of Sri BC Chakravarti nor was his name appearing in the said privilege pass. But that privilege pass, on basis of which ticket was issued, that was not been exhibited, or that was not been served to the petitioner, and that was destroyed. Rather, their version is that was destroyed, and that was also taken care of by the inquiry officer. And my lord, that is, they have stated.
Who's for the railways?
I am.
All right.
My lord, and that was there in the finding of the inquiry officer, that this has been basically that must be, my lord, kindly see, which was been destroyed. My lord, PO's brief. Then after findings, my lord, and evidence. The prosecution failed to produce, my lord, I am reading out from 34 towards last, the production of for making reservation in different class for attendant of 2 reservation slips are to be submitted as per extant provisions. My lord, got in, my lord. The prosecution failed to produce the reservation slips on demand or defense on the plea that the reservation period already expired. The whole point revolves centrally on this issued PNR for a unmerited person. Whether he has done it willfully or erroneously or to gain any benefit does not matter. Even if the prosecutioner could not produce any evidence to prove the allegation to that extent, my lord. My submission before your lordship that
Yes.
my lord,
But what the tribunal seems to say, they read bottom.
in the order itself, my lord, that in the appellate order and punishment order, they have stated that my lord, page 42, I'm showing to a lordship the points brought about in your defense regarding inordinate delay of framing charges. That is another part, my lord. I'll come to later. And non-production of requisition slip have been noted. Sri Chakravarti, being a responsible railway officer, should have verified the PNR ticket before departure. Before departure from reservation office on boarding the train immediately after the vigilance check. On 28/4/2002, attempts would have been made. My lord, this is the disciplinary authorities writing on the punishment. On 28/4/2002, attempts would have been made to collect the vital reservation slips connected with the case, which has not been done by the prosecution witness. So my case before your lordship on this point, on which basis they have initiated this disciplinary proceeding, that is not there. That has been destroyed categorically. They have admitted in 2005, as per the letter, that reservation slip has been destroyed. And during a vigilance check in the train, it was found that he has an attendant. And the mother of that officer was traveling alone and that attendant was sitting there. Whether that attendant was sitting on a ticket or he was just gone there to attend her, that was not revealed. And that was been discussed, my lord, also. And you'll also kindly see that that was also been discussed. And punishment has been given, my lord, that is my lord, page 34, that is the inquiry officer while traveling in yes. See, BCBR has not issued the PNR of 5 persons against the pass allowing 4 persons. Okay. The CO himself has admitted in answer Q3 of RUD that the above said ticket was issued. That
Saying that I issued the ticket, he means
Tickets.
he's issuing ticket for 5
my
persons.
lord, that is 4 persons ticket I have issued.
No. That statement which you have made doesn't say 4 persons and 5 persons.
That's I have issued the tickets. That is my case, my lord.
For 5 persons, you issued ticket.
And 5th person also had a ticket in the second 2 tier. That is also there. Vigilance party has also got
See,
that.
the privilege pass was meant for 4. You should ticket for 5. That's only short.
No, privilege. No. That is not so simple, my lord. The officer has to give the privilege pass, and he has given 5 names in that privilege pass.
That privilege pass was meant for 4 persons. It was not meant for 5.
No, my lord. On basis of the privilege pass, we have to issue the tickets. That is their allegation.
You could have issued only 4 tickets. That's the finding. On that privilege pass, you could have issued 4 tickets, whereas you should 5.
That, my lord, that on basis of that, my lord, privilege pass, I have not issued the tickets. That is my stand. My lord, he was another ticket in the second class. He was sitting there.
Who's going to go into all this? It's a jurisdiction. We're not supposed to have an appeal.
No, because privilege pass is not there, my lord. And the proceeding was done by in a predetermined manner, my lord, because he has not allowed to give the inquiry officer didn't allow anybody to give the
But the fact remains, my lord, till 2012, my lord, they are not considered my representation, nor return my vehicles and not accepting the money. And my lord, the as on date, the goods, the registration number stands in my name. Today also morning I have verified, the number is stand in my name. My lord, as I have been informed, my lord, it is not, my lord, I am not confirmed, but my instruction is not, he has sold the vehicle, my lord.
Some other matter has been.
In this case, my lord, I am appearing for opposite part number 2 to 4. The read petitioner has sought for issuance of direction to the private financer.
Stand the writ appeal instead of writ petition. There is no stay, Mr. Satpathy.
No, my lord, no stay, because they are already Lord, seized the vehicle before I come before this honorable court.
All right.
And this honorable court issue notice, and after accepted notice, my lord, they are not considering repeated request. I am ready and willing to pay the deposit amount.
Where is the vehicle still with them?
Yes, my lord, they have seized, my lord. They have seized, my lord, without, my lord, notice, and by virtue of the consumer court order, I have, my lord, recovered the goods and unloaded the goods. Thereafter, my lord, vehicle has been nowhere, my lord. And as on date, my lord, I have checked, my lord, this the registered number stand in my name, my lord. And I am running after the, my lord, the company. It is NBFC, my lord.
But this is a Tata truck, sir. What now?
Yes, my lord.
What will it be now? It was seized in which year? 2011.
11.
After 11 years, what
No,
are you
11 years not. In 2012, notice was issued by this honorable court.
I know, but we have to be realistic. What has happened to the truck?
That is what he has to, my lord, explain, my lord.
Yes.
I will take instruction, my lord.
Today also, my lord, I am ready and willing to
Lordship,
depose the amount.
Lordship may call this matter next week. I will take instruction in the meeting.
I am ready and willing to pay the amount.
Counsel
Lord.
for
The
the
bread and butter of the
opposite party number 2, is it?
2 to 4. I am appearing for 2 to 4.
2 to 4 needs time for instructions on the present status of the truck of the petitioner, which was seized way back on 29 June 2011. Next Monday.
Yes, please.
No, please. This is not possible.
Item 37, Your Lordship, the matter has been infructuous.
Infructuous, sorry.
Obliged.
38, Your Lordships.
Yes.
Your Lordships, you may turn to page 9, Annexure 1. Your Lordships, I'm aware the document is in Orissa. The detail of that annexure I have explained in para 2 of my writ, which is page 2 of the writ. Your Lordships, this is a khatiyan which is actually issued to my vendor. The detail is at para 2. Your Lordships may look at the detail. It's very important.
Were you heard by the ADM or you were not heard?
No, Lordships, I was not heard by the ADM.
So was your purchase after the cancellation?
After the cancellation, after the
Your
cancellation.
Lordships, there is a manipulation, a document on the face of the record. In fact, that's why on the first day, the court had called for the records, and till date, the records have not been.
The records are with me, my lord. The records are with me.
So I think, and let me just explain the documents. I think there after Your Lordships,
yes.
Your Lordships will see that the annexure 1 says that there was a lease case number 2372 of 1974. And that particular document, and annexure 1, which is issued to my vendor, is dated 1/3/1975. So before 3/1/1975, through this lease case, this particular property was recorded in the name of my vendor. And the detail of the property is thus that it's khata number 61/39, plot number 101/166.
No, but the technical point is your vendor, the lease was cancelled even before he could execute anything in your favor.
No, Your Lordship.
He must have executed a registered sale deed in your favor.
Let me just bring the facts, Your Lordships. Your Lordships, this particular area then went through an OLR proceeding, which was an SC and ST person belonging to SC/ST, which is document number 2, which is on 23/3/1985. Your Lordship, when I go for a mutation in 2011, they said they will not mutate it on the basis that there is a revision case under which the lease was cancelled. Your Lordship, that document, Your Lordship, may just see. Which is
Annexure 7.
Your Lordship, no, first is Annexure 4, where they deny, which is page 17. Did your Lordships get it?
Yes, yes.
Yes. The last few lines in that page. The case record is taken up today. The petition is absent. Discloses ROR verification. The applied land in original lease holding cancelled while revision case number 331 of 83.
Yes.
So at that point where I went and got the records of 331 of 83.
Annexure 7.
Annexure 7, Your Lordship. Yes.
Correct.
Your Lordships will see Annexure 7 states the order is 28/1/1985.
Yes.
Page 22. It talks about a lease case number 2372 of 1974,
Yes.
which is also referred in that Khatian. Your Lordships will just go to page 25.
Yes.
It says that the application for lease was for plot number 108. And the entire proceeding, the lease case on the basis of which the plot, but while sanctioning plot number 101 is sanctioned.
Yes.
Both of them have nothing to do with my plot numbers or anything, Your Lordships will see. Finally, page 26, Your Lordships will see, an order is passed bereft of any details.
That's all right. We can't go into the merits of all this.
I'm not going to
The person
merits,
who
Your
had
Lordship.
challenged this order did not challenge the order. It became
Yes.
final.
No, that's what I'm trying to say. There's a manipulation on the face of the record. There's a mismatch. What
No,
do
no,
I
no.
challenge? Your Lordships, what do I challenge? Your Lordship will kindly just hold on 1 minute. So one more document I'll show. Your Lordship will get to the point, Your Lordships. Your Lordship, this last paragraph mentions again Khata number 62, plot number 101. Does not mention the sanction date also. I went and also got the lease case order sheet. Your Lordship, the lease case order sheet is at page.
You have no locus, Ms. Ratha. Actually, that the whole point is you have no locus to challenge, because on the date the plot was conveyed to you, the man had no title to convey. That's the short point here.
Your Lordships, the lease has been cancelled on some other plot.
Whatever ground, it stands cancelled. That order has become final.
That WL case has been mentioned by virtue of which the lease was cancelled to his
Your
vendor.
Lordships, you
And
can
that has been
show me
cancelled in
WL
January
case.
85 and the petitioner purchased in June 85. Much
Your
after
Lordship
that.
will kindly look at the WL case order sheet,
Yes.
page number 20, annex 6.
Yes.
Your Lordships, the sanction of the lease was on prior to 3/1/1975.
Right.
The order sheet starts on 10/2/1976.
Yes.
This lease case has been cancelled,
Yes.
which does not pertain to the property or the document which today they have utilizing against me. So the hearing, so therefore there's a complete mismatch of all the plot numbers. You'll also look at the date, 10/2/1976.
My lord, may I be permitted to submit?
And the lease, the Khatian was of 3/1/1975. The plot number here is 62, plot number is 108 and 62. Your Lordship, the final order, and thereafter no order sheet maintained. In 1989, then there is an order saying that please resume the possession of Khata number 62, plot number 108. Whereas my property is Khata number 61/93, plot number 101/166, on which annexure 1 was granted, which reflects that the same lease case. So there is a mismatch of lease case numbers, plot numbers, and these are order sheets that they provide. And this all comes to my notice in year 2011. So this mismatch has to be put in, only they can explain that why if you've issued a document, a lease document in the year 1975, how is that the order sheet of that case starts in 1976? It's their document. And the cancellation order also, Your Lordship, the revision order is bereft of any details.
Whether it has details or not, the fact remains, if you come to page 25,
What has been cancelled is not my
plot
property.
101. Yeah, it's plot 101, which is your plot. That's been cancelled.
Your Lordship, it is plot 101 by 166. It's a different plot with a khata number 61 by 39. And the lease case, which they reflect in their own public document khatian, that proceeding should have been over by 1975. Because the document, Your Lordship, is on the
Anyway,
annex.
let's hear Mr. Monti.
Yes, my lord. Yes. My lord, what I understand from the argument of the petitioner's counsel, that he's saying that her vendor's leasehold plot has not been cancelled in the impugned RC case.
Correct,
That is
correct,
there.
correct.
If that is so, then the petitioner has no cause of action to
Yes,
come to
that's
court.
right. No grievance at all.
You have no grievance. Remain happy with that. If we have not cancelled your vendor's plot, then what is your cause of action to come to court and challenge that? That is one part of the case. Another part of the case, Your Lordship may kindly see. And if your mutation application is dismissed wrongly, then you can approach the appellate authority and convince the appellate authority that you could not have, the mutation could not have been rejected.
In fact,
That
the
is
prayer here is for quashing Annexure 7. If Annexure 7 has nothing to do with her
your
plot,
plot.
she
My
doesn't
lord,
have
that
to
is
seek
not
quashing
real.
at all.
What my learned friend is saying, that is not the correct state of affairs. Her vendor, the petitioner's vendor, is only confined to that 100 decimal. There is no other plot. That is, in one WL case, it was leased out. Subsequently, it was cancelled. I have the revision case record, entire record. The vendor of the petitioner appeared before the revisional authority, filed his show cause. It was adjudicated. Finally, the revision was allowed. Lease was cancelled. Thereafter, after 5 months, by suppressing all these facts, his vendor has sold the property to.
That's the problem. That's the
Your
problem.
Lordship, then
That is the
plot
problem.
numbers-
1 minute,
plot
Mr.
numbers-
Many, we're just listening to him. He never interrupted you.
Lordship, I'm sorry,
Yes,
I'm
yes.
sorry.
And in many cases, your lordship has dealt with this type of cases where after, had it been a case of before cancellation of lease, then your lordship would remand the matter for fresh hearing. Here is a case much after the cancellation, and the plea which my learned friend is taking, that there is a different plot and my vendor's plot has not been cancelled by Annexure 7, then she has no cause of action. Then the petitioner has no cause of, on that ground, the writ petition is liable to be dismissed. That's all.
Yes, Mr.
Your Lordships may again, I will only bring your Lordships to the lease case.
No, but
327.
why is your prayer asking for quashing of Annexure 7 if it has nothing to do with your plot?
Yes, that's your Lordship will see Annexure 1, which where the lease actually has recorded to be granted in favor of my vendor. Your Lordship shows lease case number 2372. Your Lordship, let's look at, I think some portion is
No, let us go back to, according to you, did your vendor disclose all this when he sold it to you, or he did not?
Your Lordship, my vendor did not disclose this. That's what I'm trying
Did
to
not.
That
Did
is the
not.
problem.
Did not. No,
So who should bear the burden of that?
Your Lordship,
If your vendor did not disclose, he went and contested this revision case. He lost this revision case. He does not disclose it to you, and you want that order to be set aside.
Your Lordship, again, kindly just hold. Your Lordship will see Annexure 1. It says there's a lease case 2372 of 1974, and this order is passed on 3/1/1975. Prior to 3/1/1975, this lease has been granted. But we procured the order sheet of that same very lease case. That lease case here, the order sheet which they have maintained is 10/2/1976. It's as if it starts.
Then why are you worried at all? That's what Mr. Monti is asking. Why should you be worried then? You sit pretty. If you're so convinced this Annexure 7 has nothing to do with your case, you don't have to ask for its quashing.
Annexure 7 has to be relooked because.
Why should it? It has nothing to do with your case. According to you, it has nothing to do with your plot.
Because, Your Lordships, it seeks to cancel a lease case which reflects in my Annexure 1.
So that's the truth. That's the truth.
But
And
there
that
is no
was suppressed by a vendor. So you should be suing your vendor for damages. This is a classic case of mistake of fact by suppressing a material document, material fact. You have been lured into purchasing a property.
No,
This is
Your
a case of
Lordships,
cheating.
This
Your
is not
Lordship,
a
that's what
first
I-
case
no,
where
no, no,
this type of
Your
mischief is
Lordships,
in
the, your
Bhubaneswar.
Lordships, the
Lot of
property
cases
under
your Lordship has
Annexure 1,
disposed of.
Your Lordships, again kindly, the property under Annexure 1 is plot number 61 by 93, having a khata number 101 by
If
160.
if you're so confident that you have a perfect title, then you should not be worried about Annexure 7 at all.
Your Lordships will kindly see.
So we will just record
Property-
your submission that Annexure 7 has nothing to do with your property, and therefore you're withdrawing the reputation because it has nothing to do with your property.
I mean, your Lordships will just hold on one more second, your Lordships. Your Lordships will see that annexures, this particular,
No, I'm only on this. There is only one prayer in your writ petition. You want quashing of Annexure 7.
7.
Now you've argued that Annexure 7 has nothing to do with your property.
Annexure 7, your Lordship, they seek to, your Lordship will see the description of the property they seek
So
to quash.
we will record your submission that Annexure 7 has nothing to do with your property, and therefore you're withdrawing the writ petition because that does not hurt you at all.
Your Lordships, without saying that I'm withdrawing, your Lordships may pass any order but not withdraw, your Lordship. Then
No. What does it mean? If you are so confident that Annexure 7 is some other property, it has nothing to do with your property, why should you ask for its quashing?
Your Lordships, I had brought to your Lordship's notice that it is their document. Even
they're not entering into an academic exercise. This order has nothing to do with your property. Why should we exercise ourselves and find out its legality? We don't have to.
Your Lordships, there is a reconcilement is not happening is because it is Annexure 1 is public document. Annexure 4 is also a public document, and so
It's
also
up to
the
you.
last annexure.
That's why, therefore, if you're confident of what Annexures 1 and 4 and you're happy with those documents, they protect your title, you should not be worried about anything. Then you should simply say Annexure 7 has nothing to do with me or my property. I'm
Your Lordships, my specific plea in the writ application is that the records of the original lease case.
We are going by the prayer. You're asking for quashing of an order. That's your prayer.
Lordships.
Today you've argued at length to show that order has nothing to do with your property.
Your Lordships, one of my pleadings has been that there has been a manipulation of the documents.
No. We are not. We are going by the prayer in this writ petition.
Your Lordships, one of my pleadings also to support that.
Pleadings. Let's not go around on.
Your Lordships, I have been able to at least.
We are only going by the prayer. There's only one prayer in your writ petition. You're asking for quashing of Annexure 7.
Your Lordships, that is what I'm trying to say is another Annexure 7. They have called for a lease case, which is nothing to do, which definitely reflects in my ROR.
Anyway,
which is issued in the 1975.
All right. The challenge in the present petition is to an order dated 28 January 1985, passed by the Additional District Magistrate Bhubaneswar in lease revision case number 331 of 1983. Full stop. The operative portion of the said order reads as under. Last two paragraphs of page 26. Paragraph. While directing notice to issue in the present petition, this court ordered a status quo on 20th March 2012. Paragraph. The very basis of the present application by the petitioner is that he had purchased the land in question from one Sridasa Sethi by a registered sale deed dated 5th June 1985. Full stop. It is on the basis that the impugn order of the ADM cancels the very lease of the said plot that the present petition has been filed challenging that order. Admittedly, that order is dated 28 January 1985. That is more than 5 months prior to the registered sale deed. Paragraph. During the course of the arguments, Ms. Pamirat, learned counsel, the petitioner, was candid that the petitioner's vendor did not disclose to the petitioner the fact that the aforementioned order dated 28 January 1985 had been passed cancelling the lease in favor of the petitioner's vendor in lease revision case number 331 of 1983. Full stop. It is only subsequently, when the petitioner sought to mutate the land in his favor, that he was informed that the lease already stood cancelled. So this is therefore a classic case of the petitioner having been misled by his vendor into buying the property on the promise of a good title, when the vendor fully well knew that the lease stood cancelled. Full stop. In fact, the vendor participated in lease revision case number 331 of 1983, and after hearing him, the order dated 28 January 1985 was passed. The remedy for the petitioner, therefore, full stop. Therefore, on the date that the registered sale deed was executed by the vendor in favor of the petitioner, the vendor ceased to have any title whatsoever. Full stop. The sale deed was actually null and void. Paragraph. To overcome the legal effect of the above transaction, an argument was sought to be constructed before the court today by Ms. Rath, that going by the particulars mentioned in the order of the ADM, the plot numbers and khata numbers did not match, and therefore the order itself, the order dated 28 January 1985, in fact did not pertain to the land in question.
My lord, may kindly record my objection to this submission of the petition only.
Yeah.
I object to this submission.
Yeah. Mr. Mohanty, however, joined issue on this submission and pointed out that if in fact the order, impugned order, had nothing to do with the petitioner's plot, there's no question of the petitioner being aggrieved with that order and seeking its quashing. Paragraph. Ms. Rath then referred to lease case, WS lease case number 2372 of 1974, which finds mention in the order dated 28 January 1985, and sought to submit that even prior to the said lease case, even after that said lease case was initiated, a patta had been in fact issued in favor of the petitioner's vendor, therefore conferring on him valid title.
No,
Paragraph.
prior to that date, Your Lordship.
Prior to that.
Okay, prior to that date, yeah, prior to that date, and therefore he had valid title. Paragraph. The fact remains that the petitioner is in fact aggrieved by the order dated 28 January 1985, because admittedly that order does pertain to the property which has been sold to the petitioner. Otherwise, there is no meaning in the petitioner seeking the quashing of the said order in the present writ petition. The fact of the matter is that there is no other prayer in the writ petition. The only prayer is for quashing of the order dated 28 January 1985. Paragraph. If the petitioner is so confident that the order dated 28 January 1985 has nothing to do with the petitioner's property, then there's no question of this court, at the instance of the petitioner, quashing that order. Clearly, that is not the situation. Full stop. The remedy for the petitioner, however, would be to seek damages from the petitioner's vendor for misleading the petitioner into purchasing a property over which the petitioner's vendor had no valid title on the date of the sale of the property.
Your Lordship may not observe on the title, Your Lordship, because I can still go against Annexure 4.
No, sorry. We passed the order. It's up to you now.
No, I'm
the petitions accordingly dismissed.
Your Lordship, if Your Lordship makes an observation about the sale deed, I'm just saying that may not make an observation of sale deed.
No, that's a factual position. On the day he executed the sale deed, he had no valid title to convey. That's the fact of the matter.
Your Lordship, but then in that case, the plot numbers don't match, Your Lordship. Your Lordship's observation will go wrong against the on the face of the
Ms.
record.
Ratha, we made it clear. If you're so confident, you should simply withdraw the writ petition.
Lordships.
Yes.
Has become infructuous.
Matter has become infructuous, madam.
Counsel, the petitioner states that the petition has become infructuous. It is disposed of as such.
Item 40, I'm placing the date charge, Lordship.
My lords, may kindly see the order dated 15/3/2022.
Yes.
There, my lord directed the petitioner to obtain instruction as to availability of the post of
Junior
vacant post of
assistant.
junior assistant.
Yes.
So he has not filed any affidavit to that extent.
The petitioner, your lordship, is continuing as an auditor by virtue of the interim order of the tribunal and this honorable court since 2003, your lordship. And so far as my information, my lord, junior assistant post is not available.
Which
Your
order is that?
15/3/22.
15/3/2022.
Write that order. Make a note of these things. Is there a junior assistant post?
Your lordship, as for the Directorate of Higher Education, no junior assistant post is there, your lordship.
Then you can't be adjusted, sir. As simple as that.
My lord?
Then you can't be adjusted.
No, your lordship may kindly say with regard to the other departments and the collector and DI of schools, he has opted under RTI that information will take more 10 to 15 minutes, 15 days, your lordship.
We are not going on like this.
Your lordship may kindly see the date chart.
Yes.
On 31/1/1995, the father of the petition, namely Shri Govinda Chandra Ratha, while working as assistant teacher in government UP school, retired on ground of invalidation. On 3/7/1995, the petitioner applied for appointment under the rehabilitation assistant rules. On 27/10/1999, the state government decided to establish 3 composite regional directorates to look after the matter of higher education and school and mass education. As per the said resolution, this regional director was authorized to give appointment to ministerial staffs, that is class 3 and class 4. On 15/11/1999, the name of the petitioner along with other candidates was approved to be appointed in different ministerial posts of the RA scheme by the Higher Education Department. On 24/12/1999, the clarification was sought for by the regional directors, and the Higher Education Department clarified that the candidates sponsored by the Higher Education Department may be appointed under the RA scheme. On 22/3/2000, the regional director issued a letter to the Higher Education Department that petitioner along with 6 others were not eligible for appointment. It was stated that petitioner case could not be considered as per Rule 3 of the RA rules as amended in 1998. On 27/5/2000, in response to the aforesaid, DHE clarified that the Sri Ambika Prasad Ratha is the son of Sri Govinda Chandra Ratha, who was working as assistant teacher in government UP school Unit 1 Bhubaneswar. Sri GC Ratha retired on invalidation ground with effect from 31/1/95 at the age of 53 years. As per the clarification issued by the GA Department number 3937 dated 30/11/1998, Sri Ratha is eligible to get this benefit. It is a case which was processed prior to 3/10/1998. On 21/6/2000, the petitioner was given appointment as auditor under the RA scheme. On 24/7/2003, while the petitioner was continuing, suddenly the appointment of the petitioner was cancelled as the appointment is in violation with Rule 6 of the OCS Amendment Rules 1998. On 1/12/2005, the petitioner approached the Learned State Administrative Tribunal in OA number 1120/2003 and Learned Tribunal, after hearing the counsel for the parties, was pleased to set aside the order of cancellation of appointment and directed the opposite parties to treat the entire application as representation, dispose of the same by passing a speaking order, and the interim order passed by the Learned Tribunal will continue till disposal of the same. On 4/1/2010, as per the direction of the Learned Tribunal, the opposite party in a mechanical manner rejected the claim of the petitioner on the ground the appointing authority in respect of the petitioner is DI or CI of schools and the administrative department is school and mass education department, and therefore it is not a case deserving case for appointment under the higher education department. On 13/1/2012, challenging the aforesaid order, the present petitioner filed OA number 24/2010 that was dismissed on the ground the appointment of the petitioner by the regional director is in violation of the RA rules. On 2/12/2012, this present application was filed. Your Lordship may kindly come to page. The sole ground of rejection was that my appointing authority was CI or DI of schools or the collector, Your Lordship. Your Lordship may kindly come to page 17.
One minute. So you were appointed as an auditor.
My lord.
What's the qualification for appointment as an auditor?
Graduate.
And?
Only graduate, Your Lordship.
Huh.
Your Lordship may kindly see
No,
Page,
no. Are you a graduate?
my lord,
No, sir. Come to page 50.
at the time of application, I was not a graduate. During the time of appointment, I was a graduate.
Come to page 50, sir.
50. My lord,
Just read that.
last 5 lines.
No, 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 no. Read the whole page. Rule 6.
Rule 6 thereof, the recruitment provides that for appointment to the post of auditor, one should have held the degree from a recognized university. So to be a auditor, one should be a graduate. The applicant has strongly placed reliance on the letter of the Joint Secretary to Government and Department of Higher Education to the Regional Director dated 27/5/2000 at Annexure 2. It is stated therein that the applicant is eligible to get the post under RA scheme. It does not state to which post he was eligible. However, Annexure 9 to the letter of the Director Higher Education to the Regional Director of Education reveals that the applicant was a mere +2 certificate holder, and accordingly request has been made thereof for an appointment as a junior assistant. Thus, it is explicit from thereof that the applicant was +2 certificate holder. It does not speak that he was a graduate. So, by the time applicant made his representation for appointment under the RS scheme in the year 93, he was a +2 certificate holder and not being a graduate, and he was not eligible for appointment to the post of auditor. He might be a graduate by the time he was appointed as an auditor in the year 2000, but at the time the amendment of 1998 has already been enforced, and hence the appointment could not have been imposed, having maximum of ₹6,000 per month.
So what is wrong with this? See,
Your Lordship, may
there are
kindly
two
see
problems that you're facing, right?
My
Under
lord,
the 1998 rules, you could not have been given under the RAS scheme
my lord,
appointment to a post which is carrying more than 6,000 rupees.
my lord.
Whereas this post has more than 6,000. Then
That
on
is-
the date you applied, you only applied for the post of junior assistant,
My lord.
and you never applied for post of auditor because you are not a graduate.
Yes, Your Lordship.
And now you're given appointment.
Your
as
Lordship,
a
may kindly see
auditor.
page 21.
Yes.
Page 21.
Yes.
Page 21, filling up the post of regional directors under the rehabilitation scheme. My serial number 4. I had given +2 commas, Your Lordship, may kindly see. For the
No, but the point is that you got appointed as an auditor.
My lord, after the clarification was sought for by the department, Your Lordship. Now, as per the impugned order, I have
No,
to.
that's why they cancelled it. You see,
My
they
lord.
found that you were not eligible, and therefore on
Yes.
24th July they cancelled it.
Cancelled it, and
that cancellation you went challenging before the tribunal and you lost.
My lord. The cancellation, Your Lordship, may page 43, the operative portion, page 43. That in view of the page 43, that in view of the facts and circumstances stated above, the order passed by the government dated 24/7/2003 is hereby made absolute. The appointment of Ambika Prasad Ratha by the regional director by order dated 21/6/2000 may be cancelled forthwith. The director of higher education is directed to place all the service records of the petitioner with the director of secondary education for taking appropriate action in the matter under the
But
OCS.
there is also a third problem,
my lord,
about who's the department which can give you this kind of a direction. You are coming under the schools department and not the higher education department. So
Only-
direction is being issued by some other department for appointment as auditor in the higher education department.
Only one thing after the.
So you have three problems here.
This was my application was forwarded by the elementary education lordship, the department of the father of the petitioner.
Yes.
On the last occasion, the matter was argued. This document of final. The last page, Annexure A, the last page. This is to the regional director of education, appointment of class 3 and class 4 employees under the rehabilitation assistance scheme, inviting a reference to a letter dated 3/6/2000 on subject noted above. I furnish here with the original application documents available in this directorate in respect of the following 4 candidates. The next para. Original application along with other documents in respect of the following candidates are available in the offices noted against each, are being requested to send the required papers to you directly. The petitioner serial number 1, Sri Ambika Prasad Ratha, Director of Elementary Education. The Director of Elementary Education is the department where the father of the petitioner was working, and the elementary education forwarded the documents by virtue of which I got appointment. And admittedly, during the application, I had given +2 your lordship. But a clarification was sought for. After that, I got the post of auditor lordship. Lordship, may kindly see the clarification which was sought for.
No, but you came under the school. Your father was working as
My
a
lord.
teacher. You were not in the higher education
No,
department at all.
I bring to your lordship the page 17 Because for the very first time on 27/10/1999, the directorates were created and they were the cadre controlling authority or the appointing authority. And my application was forwarded by the elementary education lordship, which I just gave the affidavit to lordship. I applied through proper channel, that is the collector and DIF schools, the erstwhile, where my father was working. My application was forwarded from the elementary education to the higher education, wherein the new 3 directorates were introduced.
Yes, Mr.
Your Lordship, may kindly on to page 49, paragraph 7. The applicant has been appointed as an auditor by the Regional Director of Education, Bhubaneswar, under Annexure 3, dated 21/6/2000, in the scale of pay of 4,750 to 7,500. The rehabilitation assistant rule has undergone an amendment in the year 1998, which effect from 7/10/1998, that in case of appointment in a Group C post, the maximum pay of said post shall not exceed 6,000. Lord Counsel for the applicant submit that the said rule having came into force from 7/10/98, the father of the applicant having retired in the year 1993, the representation was made in the year 1993. The amendment of the year 1998 is not applicable to him. The perusal of the pre-amendment provision of Rule 6, it is manifest that there was no such limit of pay in the unamended rule. But Rule 5 of the unamended rule stipulates that the deserving candidates may be appointed to any Class 3 or Class 4 post by the appointing authority of that government servant.
So
provided
you're
that,
saying that if you have to go by the rule that was applicable on the date of the application,
yes,
which is 1993, he could not have been appointed as auditor because he was only a
+2.
+2. So either way he loses out.
Yes.
Either we apply the post
New rule-
98 or pre 98.
Yes.
So for one purpose you can't say let's go to pre 98. For the other purpose say no, let's come to post 98.
Under the both the rules, he can't be appointed.
That's it.
Now, your Lordship may kindly see page 38.
Yes.
This was the clarification issued after the amendment, your Lordship. The scale of pay was never there in the pre-amended rules, your Lordship. The 3,000 to 6,000 the maximum.
No, which is the point? If you're going by the pre-amended rules, we go entirely by the pre-amended.
My lord.
All right. In the pre-amended rules, your application was in 1993. Therefore, pre-amended rules apply. There's no question of you getting appointed as auditor at all.
No,
he was only +2.
You are only a +2.
Even if I don't get as an auditor, I satisfy with
Which
junior
is why
assistant.
the court asked you if it's a if there is a vacant post of junior
No,
assistant,
in
you
the
can get accommodated.
in the
not other.
directorate where I'm working, there is no post of junior assistant.
Then that's the end of the matter, sir.
But your
Can't
Lordship may
create posts
kindly
like this. Can't create posts.
Your Lordship may kindly see the clarification, Lordship. Because my application was duly followed by the elementary education. Lordship may kindly see page.
See, even if you say that your department forwarded it and it's a regional director who appointed you, the question is that appointment got cancelled for reasons. One of the reasons for cancellation is you got appointed to a post of auditor for which you required to be a graduate. You are saying, no, let us come to 2000, by which time I became a graduate, and therefore we'll go to the post 98 scenario. If you want to go by the post 98 scenario, you could not have got appointed an auditor because it fetches more than 6,000.
My lord.
So you know you're in difficulty there. So you're going back to pre 98. If you go to pre 98, you're not a graduate. That's the end of the matter.
If I accept that also, the impugned order, the operative part of the impugned order, I have to be adjusted against a vacant post.
Yes.
Against the, your Lordship may kindly see page 43.
All right.
The vacant post under the DI or CI of school, that is the impugned order.
Correct.
I take appropriate action in the matter under the OCCC 1990, and the appointment against suitable vacancy exists under the DI or CI under SNME Department Bhubaneswar, who is the appointing authority of the deceased person, the earlier decision of the government communicated such and such. So I have to get appointment as a junior assistant under the DI or CI school of Bhubaneswar. Page 43, Lordship.
Yeah.
That is the impugned order, which has been upheld by the tribunal.
Or the challenge by the petitioner in the present petition is to an order dated 13th January 2012, passed by the State Administrative Tribunal, Orissa, Bhubaneswar, dismissing the petitioner's OA number 24 of 2010. by the said order the petitioner had challenged. An order dated 4 January 2010 passed by the Department of Higher Education, Government of Orissa, upholding the cancellation of his appointment as auditor under the Rehabilitation Assistance Scheme (RA scheme) by the order dated 24 July 2003 as being in violation of Rule 6 of the OCS Rehabilitation Assistance Amendment Rules 1998. Paragraph. While issuing notice in the present petition on 2nd February 2012, status quo is asked to be maintained. Paragraph. Interestingly, such a status quo order was initially passed by the tribunal itself in the first round of litigation in OA number 1120 of 2003. Therefore, virtually by means of interim orders, the petition has been continuing as such since then. Paragraph. The background facts are that the petitioner's father, Sri Govinda Chandra Rath, was working as assistant teacher in the government UP school. He retired on ground of invalidation on 31st January 1995. On 3rd July 1995, the petitioner applied for appointment under the Rehabilitation Assistance Rules 1990 1990 rules . On 27th October 1999, the government of Orissa decided to establish 3 composite regional directorates to look after the matters concerning higher education and school and mass education. Full stop. On 15th November 1999, the name of the petitioner was recommended by the Director of Higher Education for appointment under the RA scheme. A communication to this effect was sent on that date to the Regional Director Bhubaneswar. It is stated that a clarification was then sought by the Regional Director, and the Higher Education Department on 24th December 1999 clarified that candidates sponsored by the Higher Education Department could be appointed under the RA scheme. Full stop. On 22nd March 2000, the Regional Director of Education wrote to the Joint Secretary, Department of Higher Education, pointing out that as far as the petitioner was concerned, he was not eligible for rehabilitation assistance under Rule 3 of the 1990 rules, since the stood amended with effect from which date? 1998. What's the date of the amendment?
30/11/98.
Sorry?
30th November 98.
With effect from 30th November 1998, by virtue of an amendment to the 1990 rules. Stop.
That amendment took place on 7th of October 98.
With effect from 7th October 1990. Because the clarification is 13th November.
Yes.
7th October 1990. Full stop. Paragraph. At this stage, it must be noted that one part of the 1998 amendment was that for appointment to the post of an auditor, an applicant had to be a graduate. Full stop. The second stipulation in terms of the amendment in 1998 was that under an RA scheme, a person could not be appointed to a post which carried a remuneration of more than rupees 6,000 a month. Paragraph. In response to the letter dated 22nd March 2000, the Department of Higher Education issued a clarification on 27th May 2000, stating that the petitioner was still eligible since his case was processed prior to 3rd October 1998. Full stop. Consequently, on 21st June 2000, the petitioner was appointed as an auditor under the RA scheme. Paragraph. On 24th July 2003, an order was issued by the Department of Higher Education pointing out that the petitioner and one other person had been appointed as auditors in violation of Rule 6 of the OCS Rehabilitation Assistance Amendment Rules 1998, and that their appointment should be cancelled forthwith. Agreed with this order, the petitioner initially filed OA number 1120 of 2003 before the tribunal, and an interim order was passed staying the order of cancellation of his appointment. On 1st December 2005, the tribunal disposed of OA number 1120 of 2003, requiring the opposite parties to treat the entire application as a representation and dispose it off by passing a speaking order. Paragraph. Thereafter, on 4th January 2010, the impugned order was passed by the Department of Higher Education, reiterating the cancellation of the petitioner's appointment. Just pointed out that in the present case, in terms of the RA scheme that existed prior to the amendment to the 1998 rules, appointments could be made against a class 4 and class 3 post. And the maximum scale of pay for such posts should not exceed rupees 6,000 and rupees 2,200 respectively. Full stop. What post is the auditor's post is a group
C post.
Group C post, which corresponds to a check.
That is reflected at page 17.
No, it's not a class 3 or class 4 post.
Page 17, Your Lordship. Page 17, point number 2, last paragraph.
So even for Group C, it should not exceed 6,000.
My lord. Auditor
It
is
is further stipulated that appointment in the rules could be made once against any post, either in Group C or Group D, in a base post. And the maximum scale of pay for such posts shall not exceed 6,000 and 3,200 respectively. Paragraph. In the said order, it's further pointed out that the appointing authority in respect to the petitioner was the PI or CI of schools, and the administrative department was the School and Mass Education Department. And therefore, it was open quotation, not a deserving case to be considered for appointment under the Higher Education Department. The order concluded that, open quotation, as such, the government and Higher Education Department has taken an erroneous decision for his appointment as auditor and subsequent decision to accommodate applicant in the post of junior diarist, public dispatcher, in the office of the Regional Directorate of Berhampur, which was deemed fit and proper at that time, unquote. Accordingly, the Director of Higher Education was directed to place all the service records of the petitioner with the Director of Secondary Education for taking appropriate action and, open quotation, appointment against a suitable vacancy existing under the DI or CI under the SNME Department, Bhubaneswar, who is the appointing authority of the deceased employee, unquote. Paragraph. It is the above order dated 4th January 2010, which was again challenged by the petitioner before the tribunal by filing OA number 24 of 2010. So by the impugned order, tribunal has noted that at the time he had applied for appointment under the RA scheme, the petitioner was a +2 certificate holder and not a graduate, and therefore was not eligible for appointment to the post of auditor. So the tribunal further observed that although he might have become a graduate by the time he was appointed as auditor in the year 2000, by that time the 1998 amendment was already in force, and he could not have been appointed to a post having a maximum pay of more than 6,000 per month. Paragraph. Mr. S.D. Rautri, learned counsel, came to the petitioner, contended that the petitioner had been appointed rightly as an auditor by the order dated 23rd June 2000 by the regional director, and his application had been forwarded to the Director of Elementary Education, Orissa, which was through the proper channel. So the petitioner was already a graduate by that time, and therefore his appointment as auditor was not illegal. He further contended that since the application of the petitioner had been made in 1993 itself, in 1995, that is prior to the coming into force of the 1998 amendment, the ineligibility introduced by the amendment with effect from 3rd October 1998 would not apply to him, and his application had to be considered in terms of the rules in existence on the date of the application. Paragraph. Mr. P.K. Mudali, learned AG, on the other hand, pointed out that in terms of the pre-1998 rules, the petitioner had to be a graduate to be appointed as an auditor, whereas he was not at the time of making such application. Full stop. If one went by the post-1998 rules, in any event, he could not have been appointed as an auditor since that post fetched a pay of more than ₹6,000 per month. Paragraph. The above submissions have been considered. Stop. The undisputed fact is that the petitioner was not a graduate when he made an application on 3rd July 1995 for appointment under the 1990 rules. Appointment by way of rehabilitation assistance under the 1990 rules. Stop. Further, the position under the 1990 rules prior to the amendment in 1998 was absolutely clear that appointments could be made to either a Group C or Group D post, fetching a pay of not more than ₹6,000, ₹3,200 respectively. Full stop. Therefore, prior to 1998, there could have been no appointment of the petitioner to the post of an auditor, which is a Group C post, since the minimum qualification for such appointment was that the person should be a graduate, whereas the petitioner was not. Full stop. Therefore, even if one went by the pre-1998 position, the petitioner could not have been appointed as an auditor. Paragraph. As rightly pointed out by Mr. Mudri, if one were to go by the rules that were enforced by virtue of the amendment in 1998, that is with effect from 3rd October 1998, then again, the appointment could not be made to a post fetching more than ₹6,000 per month under the RA scheme. Full stop. Therefore, even in the post-1998 amendment situation, the petitioner is not qualified to continue as an auditor. Paragraph. Viewed from any angle, therefore, the court is unable to find any error having been committed by the opposite parties in passing the order dated 24 July 2003, reiterated on 4 January 2010, cancelling the petitioner's appointment as auditor. Paragraph. It must be mentioned here that by an order dated 15 March 2022 in the present petition, this court had required the petitioner to had noted that the petitioner was seeking time for instructions, open quotation, with regard to availability of junior assistant post, so that the petitioner can be adjusted against the said post under the rehabilitation assistance scheme. Unquote. Today, Mr. Rautri, learned counsel, the petitioner informs the court that there is no vacant post of junior assistant in any of the.
Only in the directorate post is not there. Director of Higher Education.
In the Department of Directorate of Higher Education. Consequently, the court is not in a position to issue any directions in that regard. Paragraph. The court finds no error having been committed by the tribunal in passing the impugned order.
Only one submission, Your Lordship. Since the petitioner is continuing by virtue of an interim order since 2003, the impugned order may be worked out, Your Lordship, because I will be getting appointment as a junior assistant or as against a suitable vacancy, page 43.
That is there.
That is the, Your Lordship, may kindly observe. Otherwise, because I am continuing since 2003, Your Lordship.
But we're not stopping anything, please. If they are willing to appoint you as junior assistant.
No, that is the order. That is the order to give me appointment. That is the order.
That has been upheld by this court now.
Your Lordship, may kindly observe that. Since I am continuing since 2003, Your Lordship. Since 2003, I am continuing a virtue of interim orders of the tribunal and High Court, Your Lordship.
Correct.
Yes. Special weekly item 41.
Since my power is not there, the name of Mr. Rautray be reflected, Your Lordship. Your Lordship, my power is not there in this case. The name of senior Mr. Rautray on behalf of Mr. Rautray.
Special weekly item 41.
I may be pardoned to mention, my lord. My lord, on behalf of High Court Bar Association, my lord,
41 minutes, no instruction, Lords. 41.
Counsel for the petitioner states he has no instructions. The petitioner. Yes.
Special legal list item 42.
Yes, please. None appears dismissed from opposition. Yes.
Well, item 42,
Yes.
I challenge the demand raised by annexure 4
Yes.
of page 21
Yes.
towards the short lifting of the MGQ. Well, I'm praying to your lordship that I'll approach the commissioner of excise and he may consider my grievances.
All right. Counsel for the petitioner states he wishes to withdraw the petition with the liberty to approach the commissioner of exercise for appropriate remedies. Dismiss is withdrawn with liberty is granted.
Obliged.
Special
Interim
legal
order.
list item 43.
Obliged.
My lords, item 43.
Item 43.
Yes, my lords. Item 43, I am appearing through video conferencing, my lords. This is a writ application by the Orissa Bridge Construction Corporation, my lords,
Yes.
against the order of the Learned Labor Court, my lords. Here, basically, there was a workman under us. He was a DLR employee, my lords. He remained unauthorizedly absent for a period of 3 years, and accordingly, we had terminated him.
Yes.
That is our case, my lords, and he has been reinstated with back wages
Yes.
at 25%, my lords.
That's hardly anything, sir. It's all right.
My lord,
25% is nothing these days.
my lords,
There's been a stay.
unauthorizedly absent, my lords, and he was not joining up until.
What is his age now? What is his age now?
At this time, my lords, he was 46.
So now he's 56. What was he working at?
He was
Who's appearing for the workman, sir? Who's appearing for the workman?
I'm appearing on behalf of the workmen.
Would you be prepared to go in for a mediation and have a settlement?
Well, I'll just show the award. If your lordship will just see the award.
Yes.
On 6/9/2003, they write a letter to me that we join immediately within 7 days, failing which we will consider that you are not interested to join.
Where
I
were
submit
you
my
located?
joining report on 9/9/2003, and they slap a show cause notice on me saying that you answer and otherwise you will be terminated from service. If your lordship will just look at the tribunal order, which is at page 16.
Yes.
The relevant portion is at page 16.
Yes.
Paragraph 10. From the materials available on record, it can be said that even after receiving the notice by letter number 609 dated 7/8/2003, asking him to report for duty, the workman did not respond till 9/9/2003.
So more than a month.
I'll just show that letter to your lordship. Just see further. He claims that when he received the notice, he was under medical treatment for which he could not report for duty on 9/9/2003. It further transpires that when the workman did not report for duty in response to letter number so, the management issued the letter on 6/9/2003. Now just have a look at that 6/9/2003 letter, which is at page 27. Your lordship will look at that page 27 letter, 6/9/2003. Page 27. Your lordship has it?
Yes. Yes. So 6/9, we were asked to report within 7 days.
Just have a look at page 27. That will
That's
clear.
right. So on 6/9, you were
Sorry,
on
Mr.
6/9 September.
Yes,
On 6th September,
yes,
you were asked to report within 7 days.
right.
And you reported on 9th September.
9 September.
All right. Yes,
And-
Mr. Konungo.
Yes, my lords. My lords, he was unauthorizedly absent for a period of 3 years. That's why,
Whatever. See, but this letter still gave him 7 days.
my lords, I cannot.
That's the end of the matter, sir. That's the end of the matter. We'll pass a detailed order.
On record, your lordship may say no back wages for that period.
No. Nothing
It's
at all.
only
This
25%
25% is nothing, sir. Not interfering, we'll pass the detailed order. Dismissed.
Very grateful, man.
All right.
Very grateful. Special legal list item 44.
Item 44, my lordship, the petitioner is praying for promotion to the post of officer scale 1 grade. In the meantime, my lordship, he has already been promoted. The matter is infructuous.
All right, counsel, the
So I'm
petitioner
okay
states
to,
that
sir.
because of
I'm
subsequent
okay to
development,
entry, sir.
the petition has been rendered infructuous, it is disposed of as.
Special legal item 45.
None appears dismissed in opposition.
Special legal list item 46.
Your Lordships, on behalf of Mr. Jena, item 46, 47, and 48 have become infructuous.
All right, all three infractions disposed of.
Special legal item 49.
None appears dismissed.
45, my lord, I pray for some time, my lord.
What?
45, my lord.
No, it's infructuous, you say? Yes. 45.
My lord.
Time for what?
I need some, that file has to, my lord.
Or in 45, you say the request to counsel the petitioner next Monday.
My lord.
Or
Item 49.
none appears dismissed in opposition.
Special legal item item number 50.
9 we have just been served with a copy of the counter.
The 2012 matter, sir.
Lord, this is challenging a penalty.
Whose counter has been filed just now?
Mana?
Whose counter has been filed?
State Pollution Control Board, whose order is impugned before your lordship. 49, my lord.
The 2013, sir. This counter was filed in 2013.
They didn't serve a copy. Just now they
Copy, I remember serving copy, you know, there is no noting that copy not served.
Whom are you helping, sir? Whom are you helping? By serving a 2013 counter affidavit today on him, whom are you helping?
No, he asked me a copy.
No. It's very obvious.
No, I
Counsel for the Mr. Ashok Mant, learned senior counsel, states that only today a copy of the affidavit filed by the Pollution Control Board way back on 25th February 2013 has been served on the petitioners, and he needs time for filing a rejoinder.
a short time maybe.
It is seen that since 2012, there has been stay of the decision of the Pollution Control Board demanding payment of penalty to the tune of rupees 13.77 crores. Full stop. The failure by the Council for the Pollution Control Board to serve a copy of the counter affidavit is necessitating today's adjournment. (22nd August). Interim order to continue.
Special weekly list item number 50.
Already your lordship is putting it up.
22nd August.
Interim order to continue.
Special weekly item 50.
The 50 I am for opposite party.
None appears for the petition. Dismissal.
Special weekly list item 51.
My lord, here my last yesterday only we received the counter copy, and my lord may see page 5 of the counter copy. They are reflecting 3 annexes which are not enclosed with our counter also.
Yesterday you have received?
Yes, yesterday only 26th we have received at 9:30 AM. This is my receipt. My lord, we have all.
My file shows that it was already served. Again, it might have been served. But your lordship may kindly see the impugned.
My lord, the impugned order. My lord, what has happened? The prequel to the entire case in 97, my lord, a lease deed was executed with us to have a residential building, my lord. We are in publication of newspaper, my lord. So, my lord, in 2097, a lease deed was executed. Within 5 years, my lord, we had to construct a residential quarters, my lord.
Thereafter, in 2004, my lord, the first show cause notice was issued to us. Then we wrote to them that please, the BDA approval has not come in, and we need 3.
Counter is not served.
My lord, he's saying that yesterday copy, I have no idea about that. But in any case, I would like to submit a few words before your lordship.
No, but if you filed the counter only yesterday, then he has to get time for rejoinder. So this copy not being served for 10 years and all, I've not understood this at all. You've got a copy or you still haven't got copy?
Receipt, let me see the receipt.
Sir, you have a copy or you don't have a
My lord,
copy?
here, my lord. Tomorrow.
When you have received it?
Counsel, the petitioner states he's been served with a copy of a counter affidavit dated 27th August 2012 only today. Yesterday. Rejoinder to be filed for the next date. There's an interim order, is it?
Yes, my lord.
Interim order to continue. It's on 23rd August.
My lord.
23rd August.
Yes.
Special legal list item 52.
Pardon to mention, my lord. My lord, item number 49. I am in court number 2, my lord.
All you have to wait, sir. Kindly wait.
Yes, item 52.
On behalf of Mr. Bagh, my lord, I am permitted to present. But here in this case is, the petitioner is a landless person. He applied for lease and under Orissa government Land Settlement Act, and lease was granted. And after the lease was granted on 24/1/1973. Then more than after 14 years, this under Annexure 2, the authority has revised it, saying that some procedural irregularities are there. My contention before your lordships will be that under Section 7A of the Act, on second proviso, at the relevant time, the lease can be reviewed within period of 14 years. Since this is beyond that period, the order in Annexure 2 is not is without jurisdiction.
Alright.
That order is on 19.
No counter filed, nothing, sir.
No, counter has not been. The short point is that limitation. That after 14 years, the revision has been filed.
Correct.
But I think that matter has already been decided in other cases. Your lordship may fix it to next week. I will cite some decisions. Only on this issue. I think there is no other issue of my learned senior except this.
All right. At the request of counsel for the Mr. Monthly Learned AG, list on 25th July, interim order to continue.
My lord is fixing to
25th July. Special legal list item 53.
May I please, lordship, I am for the petitioner. In this case, my lord, I have not yet received any counter affidavit.
What's the matter about, sir?
Matter about, my lord, imposition of fine by the railway authority for excess load. My lord, notice was issued in the year 2012. Opposite party has appeared, my lord, in this case.
Yes, we have appeared. Is a railway matters, my lord.
Yes. No counter filed, sir. Oh, counter has been filed by Jindal Stainless. What's this? Okay.
This may give some time in
What
the
is Jindal Stainless to do, sir?
Sorry, my lord.
What is Jindal Stainless Limited, opposite party number 3? What have they to do with this?
We are a mine owner. We have supplied some minerals to the Jindal Stainless Limited, my lord. At the starting point, the load was something, and at the end point also, they claim, railway claim that.
Party learned counsel for the railways seeks and is granted as a final opportunity. 4 weeks time to file a reply. There's no interim order here.
No interim order. No.
Rejoined for the next
along with me, Mr. Vijay Lakshmi Tripathi.
List on
Miss
19th
Vijay,
September.
name may be reflected along with me.
Special legal list item 54.
None appears. Dismissed not. Withdrawn. Dismissed as withdrawn.
Special weekly list item 55.
None appears dismissed. Not
On behalf of the revenue.
Yeah.
Special weekly list
Interim
item
order is
56.
vacated. None appears dismissed. Non-prosecution. Interim order is vacated.
Special weekly list item number 57.
May I please, Lord? My lord, the
Memo is taken on
petitioner is a poor farmer, my lord.
No
Has taken
instructions.
it
So which item are you appearing?
57, my lord.
What's the item repetition number?
Number WPC number 22.
No, wrong list, sir. This we are dealing with 9561 of 2012. Withdrawn. Dismissed as withdrawn.
Special weekly list item number 58.
My lord, item 58 for CDA, my lord.
Sorry?
I am for the CDA, Kotak Development Authority.
None appears for the petitioner dismissed. Not.
May I submit, my lord?
Petitioner, my lord. Sorry, my lord. In this case, I am the petitioner, my lord.
Yeah, tell us.
Here is the case, CDA didn't file their counter. Here is the case, we are filing application or transfer of my property in my name.
No, third
Now,
party transfer.
Lordship may see Annexure 8, page 24. My lord, it is not my case, it is thousands of cases are there. The CDA authorities make a so lengthy process, lot of transfer proceeding has been stalled. They are not going to.
Well, I think my learned friends, submission, may I submit one thing. Now this process is going on.
Complete.
I have taken instruction. On instruction, I am submitting. Let her apply in due format so that leads the process.
So may apply in the new format. We'll give a time-bound direction. They'll dispose it of.
Yes. Format on compliance of the
Mr.
affidavit.
Mahapatra appearing for the CBA states that
in that point, I have to
applies in the new format.
In that point, I am to
Then
submit something.
His application will be disposed of in a time-bound manner.
May I submit? My lord? May I submit one thing?
Yes.
My lord, what is happened in these cases? I am not blaming anybody. It is because of the after Tarata committee report, what happened? They make such a lengthy process. Lot of people said CD also undone.
That part, man, let us not enter into these disputes. In this case, I have taken instruction. On instruction, I am submitting. Let us comply the formalities and affidavit so that the deed can be executed within a stipulated time.
We have no. I think this Mr. Mahapatra has no problem. If it is a particular
Mr.
process,
Padi, we are giving a time-bound direction. We are giving a time-bound direction. You say if the petitioner applies in the new format, completing all formalities, not later than 12th August 2022, the application will be processed and the decision of the CDA thereon will be conveyed to the petitioner not later than 19 September 2022.
Must mention it was due format along with the affidavit.
Not expressed any view of the merits.
Was due format along with the affidavit required.
Whatever all required formalities have said.
Yes, yes. Everything is submitted.
Item number 59.
Yes, my lord. My lord, I am for the petitioner, my lord. My lord, in this is a covered case, my lord. My lord, last on 13/5/2013, Honorable Court issued allow a miscase and to direct.
What is the petition number, sir? What is your petition number?
Petition, my lord, 14,792.
Sir, we are now dealing with writ petition civil 9721 of 2012.
No.
Yeah, the memo is taken on record. Petitions dismissed as withdrawn. Not correct. That's not correct.
Special weekly list item number 60.
May I plead just my lord, may I submit my according my seen perhaps it is assignment of single judge.
All right. Mr. Mohanty states that this is a matter for the
service matter,
list before the roster bench.
My lord, item number
5th
59,
September.
my lord, I am for the opposite party in that case. Item number 59.
On 18 July.
My lord, I may be pardoned, item number 59.
Yes.
I am for the opposite party. My
All right, sir. All right. We'll note it. We'll note it, sir. We'll note it. All right.
Special weekly list item 61.
None appears dismissed or not possible.
Item 62.
62, my lords. The opposite party number 1 has died in the meantime, and I have filed an IA for substitution, my lords. That IA number is 14365 of 2018, my lords.
What's the matter about, sir?
But matter is about challenging the order of the Commissioner Endowment, where the order of the.
All right. What is your IA number?
IA number is 14365 of 2018.
It's not come on board, sir. No. You'll have to get it on board. Counsel to the petitioner states that he has filed an application for substitution of the deceased respondent by his LRs. The application will be brought on record. Let it come.
Interim order is there.
Interim order to continue.
Deeper
List
place.
on 2nd August.
Special weekly list item 63.
None appears dismissal numbers.
Item number 64.
My lord, this matter has been infructuous. I am permitted to withdraw.
All right. Counsel, the petitioner states that the petition has been rendered infructuous and wants to withdraw it. Dismisses.
Item number 65. Special weekly list item number 65.
None appears dismissal not possible.
Special weekly list item 66.
I am for the petitioner matter. Challenging the order passed by the Tahsildar under Annexure 3. Under Section 3B of the OGLS Act. The rejecting the lease granted in favor of the petitioner regulars.
3B, Section 5 OGLS.
Under Annexure 1, your lordship, the Westland lease was granted in favor of one BLM.
Again, no
BLM
counter filed, Mr. Monty.
My lord, appeal is provision is there. 3B.
Why don't you file an appeal, sir?
Yes,
Your
file an
lordship.
appeal.
This is the case, your lordship, where the petitioner was not heard.
It's all right.
Your
At
lordship,
that point can be
similar,
asked.
you're the lords of judgment, lots of this in this type of the lots of order.
This is ADM's order, is it?
Our own High Court, your lordship. I also
No, no,
provided.
this is an order of an ADM.
No, my lord,
This is
Tahsildar.
Tahsildar's order.
You can
Tahsildar.
file an appeal. Will
Appeal
protect
can be
you, sir.
filed
That
and
interim
all
protection
court
can
can
continue till you file the appeal.
Yes.
You say, counsel petitioner seeks leave to withdraw the present petition with liberty to file an appeal in accordance with law. If such appeal is filed not later than 1st August 2022, accompanied by an application for condemnation of delay, explaining the delay on in view of the pendency of the present petition. It will be considered on merits by the appellate authority. Till such time, the appellate authority passes an order in the application for interim relief, the status quo order passed by this order.
Under
This
Section
court
7 of the OGLS.
on 21st November 2012 will continue. The petition is disposed of in the above terms.
Item 67.
Interim order.
Liberty is prayed for in the above terms.
My lord, item 67. My lord, the work period has been over and the cause of action does not
All right.
survive.
Counsel, the petitioner states
My
the
lord,
cause of
my
action does not
appearance
survive any
kindly
law.
noted.
The petition is disposed of.
Opposite pattern 1 to 3.
All right.
Special weekly list item 68.
None appears. You are there? Draw the present petition with liberty to file an appeal in accordance with law. If such appeal is filed not later than 1st August 2022, accompanied by an application. Same thing.
My lord, originals may be returned.
Original be returned subject to
My lord,
substitution
interim,
with the attested photocopies thereof.
Item 72.
interim order is also there, my lord.
Yeah, yeah. It will continue till they pass an order.
May I please?
Item 72.
The petitioner was appointed as an emergency munship mallards in 1983 and he is superannuated from the service mallards.
Nothing survives, sir.
Mallards?
What survives?
Survived mallards, my pension mallards, my 5 years pension was not, even though it was allowed.
Counter not received. Mr. Mudali, you're there? Mr. Mudali? No counter filed yet.
72.
72. Okay, okay. He is there.
Oh, counter is there. Counter is there.
72 millards.
Yes.
The short point is whether millards the petitioner is eligible for retiring pension or millards superannuation pension.
Okay.
Millards, I'll take
Just-
my lords through certain rules.
Before going to the same issue, my lords, that I have given my lords two similar cases, my lords. That is, I have annexure 4 and 5.
Yes.
The person who has prematurely retired,
Right.
their services, 5-year services in the bar, they are taken into account, annexure 4 and 5.
But have you filed a rejoinder?
No rejoinder is required because they have admitted in paragraph number 9, my lords. Yes,
My
they
lords,
have.
I'll make good that point if my friend allows me, my lords.
If my lords will grant me, my lords, for 3 weeks time, my lords, I will file a rejoinder.
3 weeks time?
To file a rejoinder.
All right. Counsel, the petitioner seeks and is granted time to file rejoinder to the next date, before the next date. 14 September.
Item 73.
I pray for a short date, my lord. Mr. Bratha is currently on his legs.
All right. Counsel, petitioner is stated to be in some difficulty today. 19 September.
Interim order to continue.
Interim order to continue.
74.
May I please, Lords? Against the order of imposition of 25,000 rupees for delay in furnishing information, the state information.
What is that, sir? 25,000 rupees is nothing.
But I am not liable to pay because I was by that time I was not the PIU, your lordship. That I annexed to your lordship, can you glance? The information was sought for annexure 1 on 4/2/2008 with regard to procurement of the paddy crops. And 1/5/2008, the
again no counter filed.
The information commission has to do.
Somebody should file reply, sir. Nobody files means we accept what he said.
The contesting party, the information.
I know somebody is to file. I'm just saying if you're not appearing, I don't know who's appearing. We simply have to allow the petition. If you say he is not the PIO at the relevant time.
Annexure 2 is
Mr. We pass the order of the petition.
Mr. Das is appearing through VC, probably his voice is not audible. Vijay Kumar Das.
Yes, Mr. Das.
But yes, I'm appearing, but my name is not there. That is the whole problem, my lord.
But no reply filed. He says he's not the PIO at the relevant time.
And that's correct, my lord. But
then we'll allow it. We'll allow it.
Lordship kindly give some time because my name is not there.
It's all right. Doesn't be anyway. If you're not disputing the fact that he was not the PIO, there's no problem. Last 10 years, no reply has been filed. We allow the petition. We put down Mr. Dash's name.
My interim order is there.
Special Equalist item 73.
We're allowing the petition, sir.
Item 75, my lord, it is a royalty matter covered by the judgment of this honorable court. I have supplied the copy of this order. The similar cases been disposed of, my lord.
All right. Same order. Same order.
Special Equalist item 76.
Item 76, I am for the opposite party, my lord.
All right. Done appears for the petitioner dismissed. Not
70.
Interim order is vacated. Yeah.
Special Equalist item 77.
My lord, I am for the petitioner here. Annexure 2 is impugned in the writ petition, page 19. This is a letter to Bhubaneswar Municipal Corporation addressed to the Director of Horticulture, my lord. The allocation of space for opening of vegetable outlets in the brand name of Udyan Fresh, my lord. I am concerned with serial number 4 in the Sahid Nagar. If you see, my lord, this property, my lord, belongs to GA department. The GA department allotted the plot to these petitioners, showing this particular plot as a parking space. So this parking space, my lord, if you see the annexure 1, the approval plan of the BDA, they are also fine.
Not filed rejoinder at all to any of the counter affidavits. We'll simply accept the counter affidavit to be correct then. No rejoinder has been filed.
Well, counter filed by Bhubaneswar Municipal Corporation has not yet filed the counter.
I have
not. Party number 2 is
counter is not available with me. Counter Horticulture Department, he has filed the counter.
And Bhubaneswar Municipal Corporation has also filed counter.
And that
counter affidavit of the BMC be served on counsel with the petitioner today itself. Rejoinder to be filed before the next day.
In this matter, I'm appearing for
78.
Bhubaneswar Development Authority. In this matter, I'm appearing. A copy of the counter may be served on us.
All right. Copy of the counter also be served on BDA. All right.
Item 78.
Much.
It is, my lord, no instruction.
No instructions disposed of. All right.
Item 79.
None appears. Dismissed non-prosecution.
Item 80.
80, my lord. In that case, counter has not been filed.
What is the matter about, sir?
Lord, the petitioner was working as governor.
Counter is not required. This is second appeal is to file a second appeal. He is challenging the first appellate authority's order. Is to file a second appeal against that order.
Where is Mr. Saman? Who's appearing for the petitioner? You are for the petitioner?
My lord.
So there is a second appeal available apparently.
Section
Lord,
19.
it is not a order under Akti Act, but it was.
There is a
my lord,
second appeal
kindly-
available. So you can file a second appeal, sir. Counsel the petitioner seeks leave to withdraw this petition with liberty to file the second appeal as provided in accordance with law. Against the impugned order.
Liberty.
Item 81.
So 1 minute.
Sorry.
All right.
I am for the
Post
opposite.
office withdrawn with liberty is great.
I am for the opposite party.
All right.
Item 81. 81, I am for the opposite party.
81 dismissal non-possible.
Item 82.
None appears dismissal non-possible.
Item 83.
Lordship, 83 and 84, no instruction.
No instructions disposed of.
Always.
Item number 85.
None appears dismissal non-possible.
Item number 86.
None appears dismissal non-possible.
86 would be infructuous.
Item number 87.
I'm sorry. In this case, this is a batch matter. One of the matters have come up with Lordship, wherein this is challenging the decision of the state government to bring about an amendment to the Indian Stamp Act by deciding that without an instrument there shall be payment on stamp duty.
87 and 88, both are similar matters. Like in item 88, we have already filed the counter affidavit. We will adopt that counter in item 87.
You better serve a copy.
A copy be served.
A copy of the counter affidavit filed in 88. Item 88 be served on counsel for the petitioner in 87. Rejoinder, if any, be filed with the next.
My lords would kindly see this order, my lords. Order number 2 in this matter, my lords. Where Lordship has held that list this matter along with petition number 15013 of 2003.
That's the next matter, sir. That's item 88.
Other matters also which are coming up before the coordinate bench. Lordship can call here or wherever, whatever your Lordship decides.
Give us the list. 88 is not pressed, so you'll have to. In 88, you say counsel the petitioner states that he's not pressing the petition. He has no instruction, the case disposed of as such. And then 87, what order if passed? The counter affidavit filed in 15405/2013, which is adopted by the opposite parties in the present petition, be served on counsel of the petition. List along with connected matters. You give us the list.
I'll request also provide it to him. He knows it, but I'll also provide him.
Well, they have filed a counter in one of the read.
I've requested.
If they want to adopt it.
That's what we have asked him to serve it on.
Right.
List on 21st September. 21st September, sir.
Special wiki list for orders item 89.
89, my lord, I am on virtual mode.
Yes.
My lord, the order dated 7/4/2022. It was only as per my miscase, paragraph 8. Only correction is to require that in place of WPC 15293.
All right.
It will be
as prayed for. All right. The correction is carried out as prayed for.
My lord,
IA number. So we have to tell the listening people when IA is a listed, the IA number is it. Just tell them that.
as per
you ask them to come in meeting.
As per the amendment made in paragraph 8, my lord.
All right, sir.
It is required to be corrected, and your lordship is at their last order. Your lordship directed the commissioner consultation to dispose the matter within a stipulated period. That period may be extended accordingly.
Okay, the period for disposal is extended by 8 weeks from today. All right.
Other two cases, my lord, the same number only to be rectified.
Yes, sir. We'll do that.
As per the paragraph 8 of the other two cases.
All right, sir. All right.
Item 90.
None appears. This is long.
Pastoral matters item number 32.
In this case, my lords, the opposite party number one, my lord, is the accountant. Charges were framed against him with regard to misappropriation of
Who's
funds.
appearing for him, sir?
My lords,
Has he been served?
I couldn't.
Has he been served?
Yes, my lords, that is, my lord, that is charges of the charges is the mis.
Sir, has he been served with the notice in the writ appeal?
No, no, my lord.
Then how do we hear the matter without notice to him? Steps were taken or not? Steps for limitation also not taken, sir. Defect not removed. Steps for limitation have not been taken in the appeal for over 10 years now. Not entertaining it. Consequently, the writ appeal is not entertained and is disposed of. Yes.
The weekly list.
Huh.
Next list.
Yes.
Weekly list for orders item number 1.
None appears dismissed non
Weekly list.
State for members.
Oh, this is item 1.
Yes, yes.
Oh, sorry. Substitution.
Item 1 of the other one. Yes, Lord. Second list.
Right. Mohammed Shah.
That substitution have already been filed.
You have to allow it. All right. For the reasons stated, the application is allowed. And petition number 6 is deleted and substituted by the persons mentioned in the application. That is 6244, 6247. Same order for 5. All right. Both these applications are allowed. Who's for the other side, sir?
Board of Waqf, actually.
Counter also has been filed. We'll have it on some other day. None appears for the opposite parties 1 and 2. In the interest of justice, let's turn. 10th October. Interim orders are there.
Interim order is there.
Interim order to continue.
Weekly list item number 2.
Wait, please. I am appearing for the opposite party, Dredging Corporation of India.
Right.
It is already decided in favor of the assessee by this honorable court.
Okay.
And reported in 25 VST page 522. I am giving the judgments.
Yes, Mr. Padi.
My lord, there, my lord, the honorable court has 2 aspects of that judgment. My lord, only two aspects, my lord, I'll address your lordship. That judgment relates to, this is for 85, 86 to 89, 90, the under challenge, my lord, the present STRV. And in that, it was for subsequent period, my lord. So, my lord, may kindly see in that judgment. First of all, I will refer to para 21, my lord. Moreover, I am with the SCC copy. In fact, just
the sole question is, my lord, whether there has been a right to use or not under section 2G of the Orissa Sales Tax Act. And this honorable court upheld the order of the tribunal saying that there is no transfer of right. Para 12 of the judgment may kindly be seen. This is the sole question. Whether there has been a transfer of right to use.
Right.
Whether Paradip Port Trust has hired the Dredging Corporation of India for the clearing of the mud and salt, other things. The tribunal as well as this honorable court held in categorical terms that there is no transfer of right to use. It is only a service rendered by DCI.
Right.
My lord, that was the finding basing on 2 things, my lord. My lord may turn to paragraph 20 of this.
But the same SSC, same
cause of action, same.
What's the different factual difference?
My lord, factual difference is this, my lord. First, in that judgment, a submission was made that for earlier periods, the judgment of the tribunal holding it in favor of the assessee has not been assailed by the department, so it has attained finality. That has weighed in the mind of your lordship in allowing that. That has been, but by that time, the present STRVs were filed. By that time, although the STRVs have been filed, but a submission was made that for earlier periods, department has accepted the position that the tribunal has in favor of the assessee. So that's a wrong submission.
Come on. Once you have an order on merits like this is not a factual difference then.
My lord, this is one aspect. Another aspect is that in that judgment,
No, but in this judgment, they didn't stop with merely saying previous is not challenged and therefore we are upholding.
This is one.
Discuss the whole thing on merits.
My lord, two bases. My lord, two bases. One is not challenged. Second basis is at para 20, my lord.
There's no para 20.
If I'm referring to that SCC version, may I hand over this, my lord? I have two copies. The SCC version, that will be, my lord. Para 20 starts with various clauses of the agreement. In fact,
that's right.
after
We have
referring
it's
to the
para
judgment-
9 here.
Yes.
It's all right.
Various clauses of the agreement entered into between the corporation and the PPT were brought to the notice of the tribunal, and after taking into consideration the provisions of the agreement and various case laws, the tribunal, which is the final fact-finding authority, came to the following conclusion. That has been quoted, my lord. May I just only point out para 12 of that quotation portion, my lord. In fact, in the first paragraph, the clauses have been referred to. Para 12, Mr. S.K. Paul, the learned state representative, disputes the agreement, stating that this agreement was not made for the purpose of work or sale, which is currently in dispute. So there, the department stand was that the clauses which have been referred to, that are in fact not the agreement that has been entered into for that year. So two bases, one is the clauses of the agreement, another is prior period department has not challenged. Though those two bases, my lord, are my lord.
Yeah, we're not agreeing with all this. You say concerning the same SSC in relation to the subsequent year, which is this year. This judgment is for which year, sir?
Right. This is for 84-85 to 89-90.
84-85 to 80. No, it's 1991 to 92-93.
In fact, the judgment which my learned senior is referring to, that was 90 and onwards. The present STRV 543.
No, not present. I'm talking this judgment.
Oh,
in relation to the same SSC for the years 1990-91 to 92-93. This court has held in favor and involving the very same questions. This court has held in favor of the SSC and against the department. In its judgment dated, in its judgment in State of Orissa versus Dredging Corporation of India Limited.
Reported in 25 VST.
Yeah, 2009 25 VST 522 bracket Orissa. That view of the matter, both these revision petitions, which relate to an earlier period, that is 1984.
84-85 to 89-90.
89-90 are hereby dismissed. All right.
And in fact, this would dispose of item number 2 and 3.
Yes.
And in the special weekly, item number 7.
7.
Also same,
All same.
for another period.
All right. All right.
Obliged.
Weekly list item number 4.
In fact, it was delay petition was there. My lord has to delay was also there. So after pondering the
delay is
delay,
condoned. All right. Delay is condoned.
My lord, this is the case. The annexure 8 is under challenge, my lord. And the petition is the library clerk and additional charge of Malkhana clerk are suspended by the office order 13/11/2018, my lord. And the article charges
All right. Notice. He accepts notice.
Here the petitioner was the senior clerk in charge of the Malkhana.
You have to file a reply, so anyway. Yes. Reply be filed within 8 weeks. We joined up with the next day. List on 1st November.
IA has been filed, my lord, for interim protection. No.
Right. Yeah, we'll just continue for a few moments and then stop.
Weekly list item number 5.
That is a fresh matter.
Item number 5. Item 5, my lord. Matter relates to challenging the.
May be solved.
Same. Yeah. Notice the same orders.
Yes. No, my lord. That is matter relates to challenging the virus of 2004 granting rules, my lord. So after removal of defect, my lord, let it be listed after.
All right. Counsel, the petitioner seeks leave to do after seeks a 1 week's time to remove defects. List thereafter.
5 and 6, my lord.
5 and 6 both. Right.
Weekly list item 7. Item number 7.
None appears. This is a non-prosecution.
Wiki list item number 8.
Please, my lord. The petitioners
Defects. You have to
item
remove the
number 8, my
defects,
lord.
sir.
The petitioners are the villagers of the Chhatia Gram Panchayat, my lord. They have in fact approached this honorable court in a previous writ petition. The order which was passed by your lordship at Annexure 8.
There are some defects here, sir.
My lord.
You remove the defects, list after removal of defects.
1 week time may be granted.
Counsel to the petitioner states he'll remove defects within 1 week. List thereafter.
For admission item number 9.
Sure.
So we'll have it some other week, sir. We'll have it some other week.
Item 10, my lords.
Item 10.
For
Item
9, 10. Because I think it's already lunch hour.
Well, can it be next week, my lords?
Item 10, we can have it in September, sir. 10, put it on 21st September. 9, put it on 22nd September.
Interim order to continue.
Interim orders to continue. Wherever they are.
Obliged.
Item 11, madam.
11. We'll have it on other dates, sir. 26th September.
Notices has not yet gone in this matter. State is supposed to file a reply also because it's a right, a leasehold right of the petitioner will be decided by your lordships.
11, 2013 matter.
13 matter. Lord matter was argued once or twice. The lead matter was argued before the other benches, my lord. But state has not yet filed any counter.
All right.
I'll examine whether
Or
we have to file.
replies be filed within 8 weeks. We joined up for the next date, 26th September. 11th.
Item 12.
Item 12, I have to comply the order dated 4th of March 2022. There is some more time.
Counsel for the Mr. Murli seeks and is granted 4 more weeks time to comply with the order dated 4th March 2022. List on 4th August.
Item 13.
I think that's a PL Food Security Act, my lord.
I know. We'll have it on some other dates.
Yes, ma'am.
Today we were supposed to have these things at 2 o'clock. It's all gone.
Today I'm entering my appearance, my lord. This is a transfer brief. I am entering my appearance today.
Oh.
We'll have it.
July.
Well, as item 13.
26th July.
Yes. As item
Yes, item
13, my
14.
name may not be reflected.
Yeah.
Item number 20.
We have filed a progress report. He's filing his vakalat to change.
Item 14, I have filed a progress report of the investigation.
PK Jera.
That's a petition lordship in virtual mode.
23 of the list.
Call out.
Item number 14.
14, I have filed a progress report for lordship's kind perusal.
Lordship, I'm the petitioner of item 14. I mean virtual mode lordship. Lordship, not single paper is being supplied by the opposite parties to us for the state.
Where are you, sir? Why did you come here? We'll get all the papers. Where are you?
Lordship,
where are you, sir? Where are you?
Lordship in virtual mode, Lordship.
No. Are you outside the country, outside India, outside Orissa? Where are you?
I'm inside Orissa.
Please make it convenient on any convenient day to you to come here, sir. Then you will get all the papers very easily.
Obliged, sir.
May I make a small mention, members? With your lordship's kind permission, members. Item 24, can it be some other day, members? 24 of the second list. STRV 408.
Whatever dates are whatever date is convenient.
Obliged, much obliged. Much obliged.
14 is what?
Item 14.
No, he's filed something. You're saying who's in 14?
File a progress report.
A progress report has been submitted by the SPCID on 24 June 2022, stating that the investigation is likely to conclude very soon, and a final form will be submitted in due course. List on 6 September. The cop. Right, list on 6 September.
Item 15. Item number 15.
My lord, let me go any other day. I am not.
All right. Mr. Monty states is not well.
Interim order may continue.
Interim order to continue. List on 8 September.
Item 16.
My lord, item 16, my lord. My lord, in this case, petitioner challenged the virus of notifications of 2020 rules and as well as the 2016 rules, my lord, in order to get appointment under 1990 rules.
So many defects, sir?
My lord, defect is not there, my lord.
No, it's there, it's there. You remove it.
Yes, ma'am.
List after removal of
my lord, let it be listed on 7th July 2022, my lord. Similar
list on 7 July. Defects be removed.
Notice may be issued, my lord.
No. Meanwhile, remove the defects first.
Yes. Item 17.
Yes, my lord. In petition number 18607 and upon your direction of this honorable court, and last Friday we have already submitted the comprehensive affidavit.
I see. The comprehensive affidavit be served on counsel for the state.
Friday, okay, I'm giving.
No, have you served the other side?
Yes, already we have given the.
All right. We'll have it on some other day. July. 28th July.
My lord.
Item 18.
My pleasure, lordship. No, I have received the counter and there is a appeal provision. I pray my lord to dispose the petitioner liberty to file the appeal before the government.
All right. Counsel for the petitioner seeks leave to withdraw the petition with liberty to file an appeal as provided in law.
My delay petition, my limitation petition may be considered.
The appeal is filed. This is a PIL, is it?
It's a PIL, a sailing millard's order of the Registrar of Cooperative Societies.
If the appeal is filed not later than 1st August, accompanied with an application of condonation of delay, it will be considered in its method. Court clarifies it is not explicit. Right.
Item 19.
May it please, Millards. Item 19 and 20, Millards. The pleadings are complete, Millards, in this matter. Your Lordships, I understand the
list for hearing. Yeah, list for hearing on 1st November, sir.
Millards, I would pray, Millards, here is challenging the direct tax Vivad Se Vishwas scheme forms where demands have been raised against me. Millards, I pray, Millards, sometime in end of July or August.
Let's see, sir. Let's see. You may be filing an application for early hearing. Let's see. All right.
Item 21.
1st November. 1st November.
21. List item number 21.
It's complied with your lordship's direction is complied with tree is cut.
All right. Counsel to the petitioner
This is to be
confirms that the tree
disposed
has
of.
been cut and the orders have been complied with. That view of matter, no further directions are called for.
Disposed of.
Good, sir. It's disposed of. Very good. Very good.
Weekly list item.
At least something useful has happened.
It is because of the lordship's grace.
No. I'm obviously we're without grace by all your colleagues, whatever they've been saying. They have a lot of resentment. Yes.
Item 22.
Lordship, last occasion directed to the UP to take instruction, Lordship.
Yes.
May grant me some more time to file complaint.
All right. Counsel for the opposite party seeks some more time for instructions.
Item
10th officer. Sorry, 10th officer.
Item 23.
Please, your lordship. This is a public interest litigation, my lords, wherein the petitioner.
My lord, I will be filing a counter affidavit in this case. Lordship may grant some.
All right. Counsel for the opposite party seeks and is granted 8 weeks time to file a reply rejoinder for the next date.
My lords, the interim order was directed to be put up after the opposite party's appearance, my lords. There is no interim order during the vacation.
Within a short date, your lordship may direct.
All right. Within 4 weeks. Okay. We'll give a short date.
May I pray one more thing, my lords, then?
My lord,
24th
within 2
August.
weeks, I will file the counter, within 2 weeks.
24th August. 24th.
May I pray one more thing?
Yes.
Let the state be directed to produce the records regarding the correspondence between the collector and the
Whatever
education.
required records will annex to the counter affidavit.
All the relevant record be enclosed with the counter affidavit.
Obliged.
Weekly list item 24.
We'll have it on another day, sir. 24, 15th November.
Item 25.
Your Lordship, item number 25, that's a PIL petition for basic rehabilitation for the people of Jagatpur.
The same thing. Earlier it was there.
Your Lordship, Your Lordship, I agree some work, developmental work has been done, but the major issue, drainage is still the issue.
Or we'll have it on some other day. Third August. The 3rd August.
Obliged. I may pardon, my lord. No, last week, my lords have reserved one judgment in criminal appeal. Where the Mr. Ponda is appearing for the petition. Today I am filing the written note. I will serve the copy to Mr. Ponda.
Then I may be granted some time to file my reply.
So please do it within the next 2 days, sir.
I'll do it, my lords.
Within 2 days.
But I can only file by Friday. By Thursday, it may not be possible.
No. By Wednesday, sir. We want to pronounce on Thursday.
My lords, today is already Monday, my lords.
That's right. There's only 3 days, sir. We already reserved on 21st.
I agree, my lords.
Reserved on 21st.
Mr. Mutli should have served a copy at least on Friday.
It's already.
Today I am filing, I will serve copy.
Okay.
Obliged.